Yes.
Lordship, I beg to mention item number 6. I am for respondent 2 to 3, Lordship.
6. Remington Gabil.
6. Yes, Lordship.
Why?
Lordship, I am praying for 2. Lordship, the standing counsel, Mr. S. Chetia, is having some personal difficulty.
Okay, yes. Next.
Item number 5 is also connected. These are two connected matters. 5 and 6, same issues.
5 and 6.
Same
Okay.
counsel.
Yes, 2 weeks, yes. Next.
Lordship, I am appearing in item number 5, Lordship.
Very good. Okay. After 2 weeks. Yes.
Lordship, much obliged.
Lordship.
Lordship, I beg to mention item number 3. I am appearing on behalf of the petitioner.
3. Suchitra Agarwal.
I am for,
Yes, your Lordship.
Yes.
Lordship, I am for respondent 2 to 4.
Okay, 2 weeks, yes, since none of you are ready, right? Those part heard. Okay, number 4. No mention.
Item 4, my lord, it required us to produce the records. This
Yes.
is the district council matter.
Right.
We are awaiting instructions in this matter. May I pray your lordship kindly have this matter next week?
Next week. 1 week, yes. Right.
Right.
7. What else? 7, no mention. You beat up.
My lord, he's there.
He's outside.
He's outside.
Right.
Item number 1.
May I please, your Lordship, I am appearing for the income tax department in this matter, Lordship. Affidavits are yet to be filed. Lordship, I require 2 weeks time to file my affidavit, Lordship.
How many times you've taken? When was this?
Lordship, the para-wise comments are ready, Lordship. We have sent it to the department for waiting, Lordship. Some more time is required, Lordship.
2 weeks for the time as period allowed for affidavit is thereafter. Yes.
2.
Lordship, in item number 2, similar period, Lordship.
Okay. Number 2, yes.
Much obliged, Lordship.
Hearing 7.
Yes, what do you have to say? The lady. Not at all.
Lordship, interim may be continued in item 2. I am for the petitioner, Lordship.
Very good, okay. In terms of the we should continue. Whoever the interim.
Clear.
That's fine. Yes,
My lord.
he's online or he's in
My lord,
person?
he's in physical. He's just.
Yes. Where had we stopped?
My lord, we had covered 3 aspects in it, my lord. In the recovery show cause notice, we had covered the aspect where the show cause notice was given without jurisdiction first, my lord, the adjudicating authority.
This was on 74 only.
My lord, this has been argued, my lord. This was the authority which was not the authority from here, having jurisdiction and based out of this place, my lord. It was an authority from Delhi who had adjudicated. Now, my lord, apart from this, the second aspect which we had argued upon was that, my lord, there was a considerable delay of more than 8.5 years in adjudicating the proceedings, my lord, when the act itself and very categorically says and states that the proceedings have to be completed within a period of 1 year, my lord, from the date of issuance of the show cause notice. So, my lord, what they did in their affidavit which they have filed, they have tried to put a lot of blame upon us, where they said because we were writing letters to the government and we were seeking for an exemption, so that is the reason why there was a delay. Now, my lord, the act does not identify as us trying to write to the government or to any other authority or agencies to ask for any exemption when there is a delay, my lord, and for our exemption, but for them the law requires them to do the adjudication proceedings within a period of 1 year.
Notwithstanding any other consideration?
My lord?
Notwithstanding any other consideration?
My lord, it was very clear, my lord. And
the
we have
show cause was in 16.
My lord.
You say that the order was passed on?
My lord, 2025, my lord.
2025.
My lord.
And then, what is this called? Yes.
My lord, we'll find the show cause notice annexure 1 at page 119.
Yes.
If I can, 119, if I can have my lords to page 119, my lord.
Right.
Of our writ.
Yes.
Page 119, my lord.
He's coming, let him come.
My lord,
He's here.
he's here, my lord. He's just in the senior's room.
119.
My lord, page 119.
Now that we've seen earlier on.
My lord. And
And the adjudication order.
my lord, the adjudication order was passed in 2025.
That's annexure.
My lord.
Page 274.
Page 274, my lord. 12/3/2025. Now, my lord, there is a considerable delay of 8.5 years,
Let they have to meet that.
which is in this matter.
Let
My
them
lord,
meet that.
that is for them to meet, my lord, and that is where we had left the previous argument.
Right.
Senior here will continue, my lord.
I'm so sorry, my lord. I got held up.
No,
My lord, on the last occasion,
you had reached up to the adjudication order.
that's right.
Being 8 years.
That's right. So there are two issues that we have raised.
8.5 years.
8.5 years delay. And second is that the person who has
You should,
carried out this investigation show cause notice,
You see the DGCI.
that's right, he does not have jurisdiction. And for that, I had shown page 324 of my petition, where rule 3 of this,
1 second.
page 325.
324.
325,
So it's under excise rules.
service tax rules.
Service tax rules. Right? Yes, I'm saying like.
The rule says
Rule
that,
3.
yes,
1
such,
second, let me just get the page. Appointment officers. Yes.
the Central Board of Excise and Customs may appoint such central excise officers as it thinks fit for exercising the powers under Chapter 5 of the Act within such local limits. So it was within the local limit. Somebody sitting in Delhi could not have therefore exercised jurisdiction for operations in Meghalaya. And that is why we challenged the notification at page 328.
Yes.
Second last line of the first preamble itself. Rules made thereunder throughout the territory of India. Second last line of the preamble, page 328.
Yes, the table shows central powers also, and the rules made under territory of India. Yes.
Throughout the territory of India.
Yes.
So this we say is on the face or against the letter of rule 3 of the service tax rules. We says that your power is only for local areas, local limits, but here you have travelled beyond and you have notified throughout the territory of India.
Yes.
So therefore it is ex facie violative of rule 3 of the service tax rules.
Yes. Yes.
The Lord has appreciated this point. So the initiation of the show cause notice by an officer persona non grata, because this notification is bad in law, that is point 1. Point 2, inordinate delay of 8.5 years also vitiates the very decision making process.
Yes.
Now the third submission, which is where I had rested last time, is that under Article 265, your power to levy tax has to be in accordance with law.
No, last time you had gone to doctrinal bias.
Doctrine of bias in the sense that he has sat on it for 8.5 years and not examined it, and therefore to that extent. Oh right, yes. And in fact what we had also said, that the investigator was interested in the outcome.
Right. That is just.
That was the
we stopped
point.
there last
Yes,
time. Yes.
investigator was interested in the outcome, and had quoted Bombay High Court judgment also, my lord. They say that this is a completely marked by doctrine of bias. Now the next point, which is where I had rested last time, that, my lord, under 265 you have to have an authority of law to levy tax.
Yes.
Now unlike GST, where GST can be levied even if there is no consideration, under service tax, if there is no consideration, there can be no levy of tax, because consideration is the fulcrum. It is a contract for services for which there should be a quid pro quo. Whatever may be the interpretation of the provision of law, fundamentally, if I am able to satisfy this court that there was no consideration, there can be no charge of service tax. Now, I had submitted last time that these Assam Rifles officers and Jawans, there is no quid pro quo of anything for getting this benefit of life or insurance or post-retirement safekeep by the government. It's a compulsory deduction under the statute. So he who wants to serve as a Jawan or is deputed as an officer is necessarily mandated under law that before any payment is made, certain amount shall be compulsorily exacted, and which shall be put into this fund. That fund is meant for the safekeep welfare of people and the Jawans that are operating there.
Yeah.
The short submission therefore is where there is a compulsory statutory extraction. Can it be said to be a consensus ad idem of a kind where there is a quid pro quo?
Yes.
Or a consideration? And my limited submission is there can be none. I therefore wanted to show the statutory framework under which it is a compulsory deduction.
Okay.
If my lord comes to page 342, check what is happening there. Page 342. This is rules for Assam Rifles Group Insurance Scheme. The scheme shall be called the Assam Rifles Group Insurance Scheme. Now, my lord, may come straight away to page number 343.
Once I just go to definition first.
Yes, sir.
Member of the scheme means a serving AR cadre officer.
Yes. The scheme means Assam Rifle Group Insurance Scheme. Fund means Assam Rifles Group Insurance Fund. Member of the scheme means the serving AR cadre officer or JCO or 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 NCE or recruit of Assam Rifles other than one on deputation to Assam Rifles who is the contributor to the fund. Right. So clearly it's not for private citizen. Now, at page 343, para 14, objects of the fund. May I read?
Yeah.
To provide speedy financial assistance to the families of members who may die while in service. To provide lump sum terminal benefits at the time of retirement to members. To undertake from time to time scheme measures for the welfare of serving retired Assam Rifles personnel. This is for their benefit. And source of fund. The fund shall comprise of only compulsory deductions of members as per following prescribed rates. This therefore gives the statutory blessing of a compulsory exaction from the officers and the NCOs who are operating under the Assam Rifles regime.
Yes.
Now, the next page after the benefit, para 17, recovery of subscription, compulsory deduction. Kindly see this. The subscription for the fund will be recovered as follows. Officers, the drawing and disbursing officer will recover the subscription at the prescribed rate in advance every quarter. So I have no control. It is not that I have received the money and then I am making a payment like I would have done to Oriental Insurances or Reliance Insurance or whatever else. It is mandatory. Now, I also wanted to show the MHA letter, which is at page 407. Which is dated, my lord, in 1978, page 407. Ministry of Home Affairs.
Yes.
1st August 1978, Assam Rifles Group Insurance Argis. I am directed to refer to the revised Assam Rifles Group Insurance Scheme submitted by the Inspector General Assam Rifles white letter dated so-and-so 1977 and to convey the sanction of the President to the introduction of the scheme in Assam Rifles and to the constitution of a fund known as Assam Rifles Group Insurance Argis by Headquarter IGR with effect the date of issue of the sanction. This fund will be treated as an approved fund for purposes of making compulsory deduction. Kindly see this. In terms of Fundamental Rule 16 on account of subscription to the fund. This also makes it very clear. It was a compulsion. At the very next page, very first line, deduction of subscription will be from the pay and allowance of the members at the following rate. I need not boil this ocean any further. There are other places also where this compulsory deduction comes out. The short point therefore is,
You made your point. That's
yes,
compulsory. deduction.
compulsory deduction.
Yes.
Once it is a compulsory deduction, my lord, with greatest respect,
Yes.
there is no question of it being a consideration. Now I need to therefore show the provision of service tax. If my lord comes to page 313, this is the charge. It's 313.
Yes.
There shall be levied a tax hereinafter referred to as the service tax at the rate of 12% of the value of taxable services. And there are various services that are listed. So the operative part is value of taxable services. Now, taxable services, my lord, is, can you give that page? Taxable services ka definition. Section 67 defines taxable services. I'll just pass it on. In the meantime, my lord, section 67 explains value of taxable services for charging service tax. Subject to provisions of this chapter, service tax chargeable. My lord, I believe we had given it on the last occasion. Yes. It will be a loose section 67. Pass it on. Can you pass on immediately now?
No, not here. I think.
It's not there. In the, I'm getting it printed. In the meantime, let me just read it out. Subject to provisions of this chapter, service tax chargeable on any taxable service with reference to its value shall, in a case where the provision of service is for a consideration money, be the gross amount charged by the service provider. So it's purely consideration driven. And consideration has been defined to include any amount that is payable for the taxable services provided or to be provided. So therefore, the very edifice of the levy is on consideration. Absent consideration, the jurisdictional fact for imposition of the levy does not exist, because my lord knows there are four components of a valid levy: the taxable person, the rate of tax, the measure of tax, which is the value, and the taxable event. So the measure of tax, taxable value being zero, there can be no levy, because the rate of 12% has to be applied on the value. If the value is zero, then the tax is also zero. Now, this aspect, my lord, that there is no consideration also comes out from a few decisions also. Lord, in my rejoinder, my lord, will find a judgment of a division bench of the Karnataka High Court at page 57. Where is the single judge's order? Single judge copy. Let me first give the single judges. That's more detailed. You'd be giving this one, no? Joint Commissioner Tax versus this one.
This is part of the round.
Which page is this? Page 71. Well, in my rejoinder, if my lord comes to my rejoinder, page 59, I'm so sorry, page 59 of my rejoinder, annexure 3. How's that?
1 second.
Yes.
Rejoinder page.
Page 59.
Yes.
Lord, in this, you kindly have page 71. Here the meaning of the word consideration, although under GST, but this may be relevant.
Para 14.
Para 14. Before adverting to the aforesaid issue, the definition of consideration as defined in the CGST Act may be read as under. Definition of consideration reads as: consideration in relation to a supply of goods or services of both includes any payment made or to be made, whether in money or otherwise, in respect of a response to or for the inducement of supply of goods or services of both, whether by the recipient or by any other person, but shall not include any subsidy given by the central government or state government, monetary value of any act or forbearance in respect of a response to or for the inducement of any supply of goods or services, whether the recipient or any other person, but shall not include any subsidy given by the central government or state government. The Bombay High Court, in the case of Goa University's case, observed that the fee collected by university cannot be termed as consideration as contemplated in Section 7 of the CGST Act. The court held as under. We have already noticed that requirements of Section 7 of the CGST Act defines the phrase consideration in terms whereof the money or money value in respect of or in response to a supply would be a consideration. In our opinion, the affiliation is undertaken by the university in terms of the requirement of a statute, and in discharge of public function, the fee so collected for affiliation fails to qualify as consideration. The fees collected by the university, i.e. affiliation fees, PG registration fees and convocation fees, are not amenable to GST inasmuch as the fees collected by the university is not a consideration as contemplated Section 7 of the CGST Act, as the fees are collected in the nature of a statutory fee or regulatory fee in terms of statutory provision and not contractual in nature. Now, my lord, kindly turn to the next page. There is a judgment of Ahmedabad Urban Board. I am not dwelling into that. Para 37. The concept of consideration involves an element of contractual relationship wherein the person undertaking the activity of supply does so at the desire of another. In exchange of consideration, essentially
So
there
your
shall...
submission ensures that since the scheme provides that the company deduction, so the question consideration.
There is no question of quid pro quo. So therefore that is the separate on that. Now, 67 has been given. Well, let's see section 67, which has come about now.
Yes.
Subject to provisions of this chapter,
Yes.
service tax chargeable on any taxable service with reference to its value shall, in a case where the provision of service is for a consideration in money, be the gross amount charged by the service provider for such services provided or to be provided by him. In a case where the provision of service is for a consideration not wholly or partly consistent of money, be such amount in money with the addition of service tax is equivalent to the consideration. In a case where the provision of service is for a consideration which is not ascertainable, be the amount as may be determined in the prescribed manner. So we are not concerned with clause 2 and clause 3, we are concerned with clause 1. If it is money, then the amount of gross amount charged.
Yes.
And consideration has been explained. There is an explanation board. Consideration includes any amount that is payable for a taxable service provided or to be provided, any reimbursable expenditure, etc. We are not concerned with that. So it talks about the consideration as a concept under the Contract Act, essentially. Quid pro quo, voluntary, addendum, and a compulsory extraction under the statute, therefore cannot be. So therefore my submission is, at a base level measure of tax being absent, there could be no jurisdiction to levy the tax. That's one. Now I must also say that the provisions of service tax underwent a sea change in 2012. So there are two eras, pre-2012 and post-2012.
Yes.
Now, in the pre-2012, apart from consideration, I also want to point out that the taxable category under which they are trying to put me in, I would not have fallen under that. Page 303 may be seen. page 303, ZX, seventh definition, page 303.
This is from a manual.
Yes, this is from the Finance Act, my lord. In fact, it starts at page 302, section 105, my lord has that.
Yes, taxable service.
Taxable services means any services provided or to be provided, and we climb down to page 303, ZX.
Okay. Policy holder.
To a policy holder or any person by an insurer, including reinsurer, carrying out life insurance business in relation to risk of cover in life or insurance. This is what they're trying to fit me in. So the operative part is by an insurer, to a policy holder or any person by an insurer. The question that will be is whether I am an insurer. Argis is an insurer. And the later part of the line also says by an insurer carrying on life insurance business. So the question that begs consideration for my lord's consideration is whether I am an insurer. Argis is an insurer carrying on a life insurance business. Now the fact of the matter is, at page 301, the very Finance Act also defines what is a life insurance business. Page 301.
Yes. 61.
61. Life insurance business has the meaning assigned to it in clause 11 of section 2 of the Insurance Act. Now, if I am able to show to my lord that the Insurance Act specifically excludes me, then I cannot be an insurer, insurance company or insurance business. And as it happens, if my lord comes to...
I'm not life insurance business, I'm not an insurer.
Please, I have understood. Now please come to page 383. Page 383. Yes, please wait. Page 383, my lord has?
Yeah.
This is the Insurance Act. Now, in this, if my lord turns to page 400.
Where's section 11?
Page 400.
11.2. Yes.
Page 400. Life insurance business means the business of effecting contracts of insurance upon human life. Lord sees that?
Yes, sir.
Business of effecting contracts of insurance upon human life. I ask myself this question, can Argis be said to be in the business of insurance therefore? Or am I there for the benefit and welfare of my people rather than a business? If it was business, then why only the men in the uniform? Why not people on the street? So therefore, the very line which says business of effective insurance, I do not satisfy. That is point one. I cannot be said to be in the business. I am not in the money making business. And I make no profit. Now, if my lord comes to page 404,
One second.
page 404 of the Insurance Act,
Yes.
section 118. Nothing in this act shall apply, clause C. If the central government so orders in any case and to such extent or subject to such conditions or modification as may be specified in the order to any insurance business carried on by the central government or a state government or a government company as defined under 617 of the Companies Act. So even assuming that for any stretch of imagination I am said to be carrying on a business, the very fact that this is being carried out by central government, I am out of the ambit of this act. And the fact that I am under the central government, I have shown in the previous portion how the central government, Minister of Home Affairs, etc. have notified the rules, etc., etc. Now, at 406 is that order of 1978. In exercise of powers conferred by Clause C of Section 118 of the Insurance Act, the central government hereby orders that nothing contained in the said act shall apply to the Assam Rifles Group Insurance Scheme covering at all serving Assam Rifles cadre officers, all serving combatants in Assam Rifles including JCOs, ORs, NCAs and recruits, but excluding pensions, personal discharge from the services, civilian working in the Assam Rifles, any deputation and death due to so and so and so. This is issued by the Ministry of Finance. So if operation of the central government is not contemplated to be covered by the Insurance Act, then the life insurance business as defined under the Finance Act is not satisfied.
Yes.
And once the life insurance business under the Finance Act is not satisfied, there is no question of levy. So the second ground is, apart from measure of tax missing consideration, the taxable event life insurance business is also missing. Now there is a third element, my lord. My lord sees the LIC Act, section page 380. Page 380, section 44 of the LIC Act. Clause F, clause 44, not to apply it in certain cases. This act does not apply to certain cases. That clause F. Any scheme in existence on the appointed day or any scheme framed after the appointed day with the approval of the central government, whereby in consideration for certain compulsory deduction made by the government from the salaries of its employees as part of the condition of services, the payment of money is assured by the government on the death of the employee concerned or on happening of the contingency dependent on his life. So they said the Life Insurance Act also will not cover such kind of situation. Now what is that notification that is relevant? That will find at page 382. This is a 1978 missive of the Ministry of Finance. I am directed to refer to the Assam Rifles Group Insurance Scheme sent by the Director, Ministry of Home Affairs in file number so-and-so 25th July 1978 and to convey the approval of the central government under section 44F of the Life Insurance Corporation Act to the aforesaid scheme, which will cover all serving Assam Rifles cadre officers, all serving combatant, etc., etc., same language. So neither the Insurance Act nor the Life Insurance Act
On the same day, these two
on the same day.
406 and,
Yes.
and 322.
Right. So it is as clear as daylight that I am not in the business of life and insurance, which is a condition precedent for invocation of the levy under section 66 of the Finance Act. So that's my submission insofar as pre-2012 is concerned. Now post-2012 there has been a change in the law. But I kindly have page 315. Because the distinction between the pre-2012 and post-2012 is in pre-2012 you have to fall into one of the pigeonholes to be liable to tax. You are a business auxiliary, you are a manufacturing not amounting to this, you are an exporting this, the categories of that. But in the post-2017, 2012, it was on a negative list basis. So may I read page 315? The principle was, if you fit into negative list, then you are excluded, otherwise the whole universe is taxable. That is the rule. So the whole universe is taxable sans what is falling into the negative list. That's why it's called the negative list regime. So 315, section 66D. The negative list shall comprise the following services, namely, now kindly see this, services by government or local authority, excluding the following services to the extent they are not covered elsewhere, which means all services by the government shall be excluded from levy unless it fits into one of these 1, 2, 3, 4. So the question will be whether I fit into these 3 or 4, the subclause. First subclause which is relevant, services by Department of Posts by way of speed post, express parcel, post, life insurance and agency services provided to a person other than government. I am not a Department of Post. So if I was Department of Post and I was carrying on life insurance business, then yes, I would have been taxable. So once I don't fall under the exception of 66D subclause I fall outside the net of service tax because I'm in the main negative list, which is services by government. That is what is intended to be excluded. Now, the question is, am I a government? Lord, Article 12 applies to me. If there is any infraction of fundamental right, they would come before my Lord and invoke 226. And I'm sure my Lord would have seen any number of 226 that would have come before my Lord against Argis or Assam Rifles, so to say. But be that as it may be, there's this interesting judgment of the Supreme Court for AFGIS, which is the Air Force Group Insurance Scheme. I wanted to place that for my Lord's consideration. This is the judgment of 12th March 2026. So it's a very recent judgment. This is the case of Ravi Khokhar and others versus Union of India. Para 1, Para 2. The controversy in a nutshell. The appellants are employees of Air Force Group Insurance Society. We are Assam Rifles Group Insurance Society. Established under the Societies Registration Act in the year 1976 with sanction of the Honorable President of India, having been received in the same year on 6th October. The dispute germane to this list is that while the Board of Trustees, even I have a Board of Trustees, had wide special meeting dated 27 December 2016 decided that the pay scales of the workers would be revised in accordance with the 6th pay scale of the Government of India. Subsequently, by way of meeting dated 13 February 2017, resolved that pay structure would be revised in a way that any linkages, connection to and pay parity with the central government by virtue of pay commission be done away with, and accordingly therefore thereto asked all employees by way of notice dated so and so to sign their acceptance to the revised terms. The appellants agreed, were thereby filed a writ petition before the Delhi High Court, which were dismissed by the common judgment dated 1st December 23. The findings of the learned division bench can be summarized below. The court's central finding was that none of the respondent organization, namely Air Force Group Insurance Society, the Air Headquarters Non-Public Fund Organization or the CRBS Employees Educational Society could be stated as state or other authority within the meaning of Article 12 of the Constitution of India. This determination was foundational because the court held that unless the respondents satisfied the requirement of Article 12, the writ petitions under 226 were not maintainable and the court cannot adjudicate the claims relating to the pay parity, service condition, promotion, etc. etc. In examining the status of Air Force Group Insurance Society, the court found that it is a society registered in the Society Registration Act, established 1976, as a self-contained and self-run welfare and insurance scheme meant exclusively for Air Force personnel and their families, identical to what I do.
Yes.
While senior Air Force officers form part of the Board of Trustees and certain officers are posted with the society on deputation, the court held that this association does not translate into deep or pervasive government control. The day-to-day administration of the society is carried out under its own internal governance framework and its finances are sourced entirely from member contribution and the insurance fund rather than from a budgetary allocation or grant from the central government. The court placed particular reliance on the appointment letters of AFGIS employees which expressly state that their service conditions are governed by the rules of the society as amended from time to time. The court noted that there is no statutory or contractual guarantee of parity with the central government employees and the allowances and pay structure are subject to approval of the Board of Trustees. The court therefore concluded that even if historical parity with central government pay scales had existed in the practice, it did not create any enforceable right, nor did it convert AFGIS into instrumentality of the state. This is what the division bench held. Now, when the matter travelled to the Supreme Court, if my lord comes to internal page 16, para 8. Lords are there? We now proceed to evaluate the rival contentions in the light of the judgment referred to supra. It is not in dispute that membership of AFGIS is compulsory for all officers and airmen, identical to my case. The contribution of premiums are automatically deducted from their salaries, identical to mine. The Board of Trustees comprise entirely of senior serving IF officers, exactly my case. Services at AFGIS is considered to be proper deputation of officers and the sanction for this body as also its deputation rules were granted by the Honorable President of India, identical to mine. AFGIS periodically reports this financial transaction to a senior officer in the IF, same as mine. In his letter dated 15 December March 2016, AFGIS itself accepts its position as government. The President has accorded sanction on separate occasions, introduction of substantive post in the society's specification of pay bands, and H. The society is exempt from various taxes given its compulsory nature, as also automatic deduction from pay. AFGIS had a monopoly over insurance for IF business, IF members. Let us unpack these points. Now, para 9, I'd like to come to the next page, 3C, basis of working of AFGIS. Lots are there?
Yes.
Consequent of the aforesaid sanction approval, the contribution by air warriors to AFGIS have been made mandatory and compulsory in terms of Air Force Instruction AFI 1687 issued by the Government of India Ministry of Defence. The monthly mandatory contributions are compulsory deducted from the salary of all air warriors, officers, airmen and NCEs from the day they join IF. Hence, membership to the group insurance has become an integral part of the service condition. It is pertinent to mention here that the AFGIS, like Army Group Insurance and Naval Group Insurance, caters only to men in uniform and is not open to civilians or the general public. AFGIS does not issue any insurance policies to air warriors or for its insurance schemes. Relationship with AFGIS and its air warriors. One of the primary factors for deciding the applicability of service tax is the relationship between service provider and service receiver, wherein there is a flow of service. AFGIS is a self-contained society run departmentally under the authority of Government of India Ministry of Defence. The insurance schemes run by AFGIS are exclusively for the air warrior members, hence the group is closed group. Members and contribution to the schemes is compulsory and mandatory. Following examples regarding decision by the courts could find clarity. In the case of Statutory Club versus Assistant Commissioner Service Tax, so the Honourable High Court of Calcutta observed that principally there should be an existence of two sides entities for having transactions as against consideration. In a members club, there is no question of two sides. Members and club both are the same entity. One may be called as principal while the other may be called as agent. Therefore, such transactions between themselves cannot be recorded as income, sale or service as per applicability of the revenue tax of the country. It's the mutuality. It's like a member of a club and the club is one and the same. Or a partner and a partnership is one and the same. In a matter of New Delhi CSTAT, in the case of Federation of Indian Chambers of Commerce Industry FICCI versus Commissioner of Service Tax, wherein the tribunal held that services by FICCI to his members is not liable for payment of service tax owing to the principle of mutuality. AFGIS is controlled by Government of India through Ministry of Defence, Air Headquarters and hence a government in terms of Finance Act. AFGIS acts as a wing of the Government of India and hence the collection received by its member is outside the purview of service tax. Exactly the point that I was trying to canvass a little while back. Purview of service tax primarily on the basis of principle of mutuality by virtue of section 66D of the Finance Act, wherein the service of government is outside the purview of service tax, which is precisely what I was trying to canvass. Having said all of that, Supreme Court thereafter at para 17, this is the crux.
15.
17, internal page 30, Lord.
Yeah. I count 15 first.
Yes, Lord. In our view, a perusal of the documents extracted supra make out a case for AFGIS to be considered a state.
Okay.
Within the meaning of Article 12, for the aspect of deep and pervasive control, we observe the Honourable President of India granted sanction for AFGIS to be established and also specifically approved the deputation rules. The principal director of AFGIS every month is to apprise the Assistant Chief of Air Staff regarding the cash flows of AFGIS, which ensures monitoring of the
He's held here that I'm checking.
It is a state.
It's entirely in the hands of government service.
Correct. So therefore, the
the same as AFGIS.
Absolutely, same as mine. Now, having said that, at para 17, their lordships say,
Yes.
in fact, para 16, we are unable to accept the contention. It may be that in so far as financial aspects AFGIS is concerned, the government may not have direct role. However, for a body to be held to be a government, to a state, it is the cumulative effect and impact of deep and pervasive control, financial administrative control, along with other factors such as carrying out of public duty. This is the most important thing, the public duty part. Para 17. We are of the considered view that AFGIS does indeed perform a public duty, which is same as ARGIS. The protection and welfare of armed forces personnel is a core government function. And I submit that this is exactly what I do. It's a core government function. I am protecting the life of the Jawans and the officers in the Assam Rifles. Same. It's a government function. The role of the armed forces is directly linked to the sovereignty and security of the nation, and in protecting the same, members of forces are required to adhere to, abide by and maintain a strict set of rules, unquestionable conduct, and at times in the most severe and adverse circumstances, thus providing insurance coverage is a public function as it addresses a collective obligation the state has towards defined public class whose service is indispensable. A body in effect becomes a conduit for discharge of that obligation. The role of the state in protecting them does not end up upon their superannuation from service, for the life of a person from the forces is forever shaped by their time in service. Insurance to service members is a critical.
Got it, yes.
So therefore that is what it is at para 18. In addition to the discussion above, it is also seen that one point Avgis itself claimed to be government while claiming all an exemption from service tax since it is under the control of Minister of Defence. In effect, by opposing the challenge to the appellant, Avgis has resiled from his own statement. We fail to understand an organization can be government for one purpose and not for the other purpose. So ultimately they said you are a government. Now my respectful submission is, basis this judgment, it is now clear that a body created under the aegis of the President of India through statutory rules, interference of the central government, Ministry of Home Affairs, Army Act, Air Force, Army Act, Assam Rifles rules, is nothing but discharging public function for the care of their men in uniform. It is government. And once you are a government, the negative list opening line which says that the levy shall not apply to an activity carried out by the government or a service by a government would spring into action. Because section 66D, as I read out at page 315.
Yes.
The negative list, section 66D says
Services
that,
by government.
yes, services by government.
Yes.
But if I was a department of post, then maybe yes, because postal department also renders insurance to the villages, etc. People do take that. But we are not department of post. So therefore, my lord, my respectful submission is,
You're not an insurance company.
I'm not an insurance.
And you're a government.
I'm a government.
And so you're under 660.
Correct. Now, what is also important, my lord, is there is the definition of government. They, at page 623,
so Mr. Ghosh, how did the regime really change post 2012? Because
so as I said,
2012 is quite clear. You have those two notifications, 78, so on and so forth.
Correct.
Now, but after 2012, how did it?
Yes. So the difference is
that they have brought you under this.
Yes, I'll try to explain.
Yes.
Pre 2012, it was pigeonhole.
Yes.
You do engineering services, you're liable. You do insurance services, you're liable. You do X, Y, Z. There are about 30, 40 of services. I had to fit into that.
Now, post 2012,
a whole universe of service is taxable unless you are in the negative list.
Right.
So that time
now you made a submission. So maybe assuming we accept your contention that you're in a negative list, taking into account the judgment passed by the Supreme Court. Also, yes.
So once I'm in the negative list, I don't fall under the taxable services.
Yes.
Because the charging section says, my lord, if my lord comes to page 314, page 314.
Yes. Section 66B.
66B.
Yes.
This is charge of service tax on and after Finance Act 2012. Yes. There shall be levied a tax hereinafter referred to as service tax at the rate of 14% on the value of all services other than those services specified in the negative list. So if you fit in the negative list, then you are out of 66B. And I fit into negative list because I provide government. I'm a government. Now, what is also important, I must also point out that the meaning of the term government had also undergone some kind of change. Post 2015, post May 2015, the definition of government warranted that the account should have been audited by the public under Article 150. Where is the provision? And I wanted to show, kindly have page 624. The provision which is 150 reference. Page 624. Hmm? 625. No, that I have. I'm thinking that 150 reference. Page 624, my lord has.
Yes.
Yes. In fact, my lord, have page 309 first. page 309. Because this definition of government for service tax went through a change on 14th May 2015. I wanted to read the new definition.
Yes. Now we are good.
Right. Government means.
Yeah, 26A.
Yes, 26A. This is effective 14th May 2015. Government means the departments of central government, the state government and its departments, and a union and its departments, but shall not include any entity, whether created by a statute or otherwise, the account of which are not required to be kept in accordance with Article 150 of the Constitution. So Article 150 of the Constitution is a condition precedent being made for other ancillary bodies who was trying to claim the status of a state. Now Article 150, in fact I want to show, if my lord comes to page 620, sorry my lord, page 624, Government Accounting Rules 1990. Has that?
Yes.
The very next page, clause 6. May I read?
Defense Department.
Yes. Special provision relating to railways, posts, telecommunications and defense departments. For the sake of practical convenience, the forms of accounts including appropriate accounts relating to railways, posts, telecommunication and defense department may be determined by the departmental accounting authorities within such a range and covering such aspects as may be prescribed by the central government in the Ministry of Finance, Department of Expenditure, Controller or General of Accounts, on the advice of the Controller and Auditor General of India. The provisions of Article 150 of the Constitution will be deemed to have been satisfied if the forms so determined are not questioned by the Controller General of the Accounts and the Controller General of Audit. So 150 is deemed to be complied with. So far as my operations as the Defense Department is concerned,
Defense Department, whether qualified Defense Department?
it will be, my lord, and that I wanted to show. Kindly have page 333.
Page?
Page 333. Because the origin of Assam Rifle has to be traced to the Army Act. Page 333, my lord, has that. May I read?
Yes.
Application of the Act, which is the Army Act, to Assam Rifles, 1960. So, in exercise of the powers conferred by subsection 1 of so-and-so of the Army Act 1950, the central government hereby extends all the provisions of the said Act to the personnel of the training etc. of the Assam Rifles, being a force raised and maintained in India through the authority of the central government during the period they are attached to the army. So, a force raised by the central government, operating under the Army Act and attached to army regimental centers or other army units for the country, is nothing but a defense department.
Ministry of Defense issues the second disorder.
But doesn't come under Ministry of Defense.
It does. 334.
I think it hasn't the character changed after 1960?
It has not. So page 334.
Especially the command structure.
It has not. So kindly have page.
Has it changed?
Assam Rifle is under the operational command of Army.
Army is operational.
Operational command is under Army.
But under the MHA.
But under
MHA. That bifurcation happened, but the control from the Army Act it went to MHA, but the underlying statutory structure remained the same. And it, in fact, at page 334 we have that.
Sir, even under the new Assam Rifle Act, we are the armed force of the Union of India.
Lord, I'm told that under the Assam Rifles Act we are under armed forces of the Union of India. I'll show that. In fact, I'll show that. But before
it is a where's the new Assam Rifles Act?
Yes, my lord.
At least a legible print.
I have, in fact, if Milord, just one sec, I'll just show. If Milord comes to the Assam Rifles Act, do you have it?
Yes.
Okay.
This is a bit, I find it difficult to read.
Milord, comes to page 336.
Type copy?
Yes, there's a type copy. This is the Ministry of Defence notification. Milord said, ask me this question.
Yes.
Page 336, SRO 117.
Yes.
Ministry of Defence notification SRO 117 dated 20th March 1960. In exercise of powers conferred by subsection 1 of the Assam Army Act 1950, the central government hereby all the provisions of the said act to the personnel of the training of the Assam Rifles being a force raised and maintained in India by the authority of the central government during the period they attached to the army regiment center or other army units. So this is the Defence Ministry notification. By the Defence Ministry notification, the beginning, my lord. Then 338. This is 1962, 6 December 1962. This is Ministry of Defence. In exercise of powers conferred by subsection 4.1 of the Army Act and the supersession of notification of the Government of India in the Law, External Affairs Department so-and-so 1948, as subsequently amended, central government hereby applies to every unit of the Assam Rifles being a force raised and maintained in India under the authority of the central government, all the provisions of the said act except those specified in Part A of Schedule Annex thereto, subject to the modification got forth in Part B of that schedule when attached to or acting with any body of the regular army. So I guess this is the Ministry of Defence notification. Then, my lord, the Assam, the rules, page 340. Page 340, again by Ministry of Defence. This is the notification 27 November 1954, SRO 484. In exercise of powers conferred by 191 of the Army Act and all other powers enabling in this behalf and the supersession of the Indian Army Act rules and the Army Act 1950 published with the notification of the Government of India and the late Army Department so-and-so and the Ministry of Defence number so-and-so, the central government hereby makes the following rules. This is the Army rules and 341.
Authorised deductions.
Authorised deductions. And 342 is the rules for Assam Rifles Group Insurance, pursuant to which this was.
That you please me.
Yes. And page 348.
Shifted to the Assam.
Yeah. Then page 347. Somewhere in between the Assam Rifles Act came into being. Page 347. Now 2010.
Yes.
(2006) is the Act in exercise of powers conferred by Section 165 of the Assam Rifles Act 2006. So from Army Act it came to Assam Rifle Act, and under that at page 348. Yes, I'll just read it. At 348, para Section 202 talks about authorized deduction, and the preamble of the Assam Rifle Act 3rd November says an act to consolidate and amend the law relating to governance of Assam Rifles and armed forces of Union for ensuring the security of the borders of India, to carry out counter-insurgency operation in the specified areas and to act in aid of civil authorities for maintenance of law and order and for matters connected therewith. So the operative part is an armed force of the Union, and therefore that is a defense in that sense.
Only one question.
Yes,
now, after the show cause notice issued 2016,
right,
in the intervening period, while all these considerations were very placed for the ministry or before these tax authorities with regard to the nature.
That's a fair question, my lord.
Nature of the
yes, my lord.
nature
what
of ARGIS.
Yes,
and whether it's considered in the adjudication order.
Unfortunately, the judgment of the Supreme Court was not available because it's a March 2026.
Okay, so if you feel now the whole dimension has changed.
Whole dimension is changed. It is government. What the learned adjudicating.
Government will come to a negative list. That
absolutely.
What
the learned adjudicating authority says is that look at your PAN number. You are registered as a trust. Therefore, you're not a government. I wanted to show the finding. It is as perverse as it gets. If my lord sees para 9, Page 283. Page 283.
Yes, Mr. George.
Yes, sorry, page 282, para 8.2.
Right. For 8.2.
Yes.
Yes.
It is observed that the fourth character of the pan of Argis is T, which represents a trust. This fact is also corroborated by letter dated so issued by Commandant P.A. Matthew, Director Argis, wherein in response to specific query by this officer as to Argis is a trust or otherwise, it has been admitted by the director that Argis is a scheme run under the aegis of the Board of Trustees. Therefore, it is evident that Argis is a trust and not a government. So we told them government. He looks at my pan and says you are a trust. And in fact, in the Afghis thing, Afghis was also a trust. If my lord comes to para 8 of the judgment of Honorable Supreme Court.
Understand.
Yes, there also it is referred to at clause B, the Board of Trustees.
Naturally, you're operating your own account, you have to have your own PAN number, yes.
Correct. So therefore, this aspect that we are a government was taken before him. But in a perverse manner, he boots me out.
Yes.
And he concludes why I am not on the negative list if my lord comes to page 283.
Yes.
Para 9.3.
Yes.
Negative list under section 66D of the Act. Life insurance service is not covered under section 6D of the Finance Act. Clause A of section 6D puts certain services provided by government or local authority beyond the purview of service tax levy with effect from 1/7/2012 to the exclusion of the life insurance services. Meaning of the government or local authorities. Para 9.4, section 323 of the General Clauses Act defines government. Government shall include both central and state government. Further, in terms of clause 26A of section 65B of the Finance Act, the government means the department of the central government, a state government, and its department and the union territory and this department, but shall not include any entity whether created by a statute or otherwise, the accounts of which are not required to be kept in accordance with Article 150. I read it out, and then at para 9.8 he says, according to the definition, government shall not include any entity or enterprise which has been created under the statute or otherwise, the accounts of which are not required to be kept as per Article 150 of the Constitution of India framed under 150. Usually such accounts are also subject to audit by officers of the CAG, whose report is submitted to the President, who then causes them to be laid before both houses of the Parliament. In case of states, report is submitted to the government of the state, who shall cause them to be laid before the state legislature. Thus, only those departments whose accounts are so prescribed and maintained will be governed by the scope of government, are entitled to benefits and privileges of exemption from payment of service tax available to the government and negligible. In the instant case, the accounts of Argis are being audited by independent chartered account, not CAG. They are preparing their annual balance sheet in the name of Assam Rifles Group Insurance Scheme, and their auditors are Mr. Sham Shetri and so on. So further, it is noticed that Argis is a trust and all the expenditure of Argis, including salaries of the employees, is made from the fund of Argis, and the same is not made by the Consolidated Fund of India. Now I ask myself this question, Consolidated Fund of India, is that a criteria? Supreme Court in Afghis says no. So far as this audited by so-and-so Mr. Chetri and company is concerned, I have shown the accounts rules say that if you do it in that manner, it will be deemed to be approved under section Article 150. Now you do not consider this and then come to a conclusion at para 10. From the above, it appears that Argis is not a government and it's a trust.
So the crux of the whole thing.
That's the crux of the whole thing.
Right.
Now, my lord, one other thing which I must also point out is that a judgment of the Karnataka High Court a single judge's judgment on insurance. This is Kerala State Insurance Department versus Union of India. Single judge.
This 2012-28 STR.
That's right, my lord. 2012-28 STR. Para 12.
Yes.
Section 44F of the LIC Act, which also excludes me.
Yes.
44F, the LIC Act is very much clear and category to the effect that it excludes any scheme in existence on the appointed day or any scheme framed after the appointed day with approval of the central government in consideration of certain compulsory reduction made by the government from the salary of its employees as part of the conditions of service, assuring payment of money on the death of the employee or happening of any contingency dependent on his life. Then para 16. Coming to the case decided by the High Court of Karnataka, referring to the concerned circular, copy of the said circular has been produced in the present case as so and so of the circular relevant and hence which are extracted below. a number of sovereign public authorities, i.e. agency constituted set up by government, perform certain functions, duties which are statutory in nature. These functions are performed in terms of specific responsibility assigned to them under law in force. For example, the regional reference standard laboratories undertaking verification, approval and calibration of weighing and measuring instruments. The regional transport officer RTO issues fitness certificate to the vehicles. The director of boilers inspects and issues certificate for boilers. Of explosive department inspects and issues certificates for petroleum storage of a tank LPG in terms of provision of the relevant laws. Fees as prescribed is charged and the same is ultimately deposited in the government treasury. A doubt has arisen whether such activities provided by a sovereign public authority required to be provided under statute can be considered as the provision of service for the purpose of levy of service tax. The issue has been examined. The board is of the view that the activities performed by sovereign public authorities under the provision of law are in the nature of statutory obligation which are to be fulfilled in accordance with law. The fee collected by them for performing such activities in the nature of compulsory levy as per the provision of the relevant statute, and it is deposited into the government treasury. Such activities purely in public interest and it undertaken as a mandatory and statutory function. These are not in the nature of services to be particular individual for any consideration. Therefore, such an activity performed by a sovereign public authority under the provision of law does not constitute provision of taxable services to a person, and therefore no service tax leviable on such activity. However, if such authority perform a service which is not in the nature of statutory activity and the same is undertaken for consideration not in the nature of statutory fee levy, then in such cases service tax would be leviable if the activity undertaken falls within the definition of tax service. From the above circular issued by the central government, it is clear that when the insurance department is collecting premium providing insurance coverage as part of the duty cast upon them, it assumes a character of compulsory levy as per relevant provision of the Act. Such activity is purely in public interest and is undertaken as a mandatory statutory function. In those cases, service tax is not leviable. The said provision has been highlighted by the division bench of the Karnataka High Court in so and so, making it clear that if the government authority performs a service which is not in the nature of statutory activity and the same is undertaken for consideration not in the nature of statutory fee levy, then in such cases service tax could be leviable and it falls within the ambit of tax services. It was accordingly that a finding was rendered that the particular type of insurance coverage being undertaken by Karnataka State Insurance so and so in respect of motor vehicles was liable. Viewed from the above facts and circumstances, this court finds that the activity being pursued by the petitioner in providing life insurance coverage to the employees of state government as part of statutory obligation giving effect to Rule 22 of KRS is not a taxable services. This was appealed before the division bench. It is there in my rejoinder at page 57. It was affirmed. Para 5 and 6. Page 57. Para 5 and 6.
Short judgment.
Short judgment. It has DB has reappreciated and said this is perfectly in line with law. Para 5 and 7. I am not repeating that in interest of time. Therefore, my lord, my concluding submission is as follows. A national footprint of DGCI under the Finance Act.
That's your first.
Because local area does not fit. Yes. That's fine. So they could not have initiated the proceeding to begin with. B, 8.5 years of delay.
Yes.
It's an abuse of process of law. And to that extent, arbitrary action. C, inherent bias in the investigator wanting to have an interest in the outcome. Bombay High Court decision I had quoted. D, jurisdictional, Article 265 not satisfied. There is no authority of law because pre-2012, consideration 0. Life insurance business I do not carry out. I am excluded from the LIC Act, I am excluded from the Insurance Act. It is all pervasive government control, Afghis judgment of Supreme Court. It's a public duty being rendered.
Yes.
It is a service to self, if at all. It's like the members and the club members and the club itself. Mutuality concept. Partner and partnership. Transaction interest between partner and partnership is never a service. Otherwise, every time there is an equity contribution to the partnership, there will be a tax. Post 2012, the negative list carves out exception to government services. I am government for all the reasons that I have stated, all the notifications, structure of the statute, Government of India, Defence Ministry notifications and so on and so forth. And the fact remains, I do not deal with civilians.
governmental functions according to Supreme Court.
And as the Supreme Court says, what I discharge is a core government function, public duty. All pervasive control. Consolidated Fund of India is not the only criteria.
Yes.
Therefore, beloved, my respectful submission is the impugned order ought to be quashed on this jurisdictional issue itself.
What about last time? I think it argued something natural justice. You had brought up the point of violation of natural justice.
That was on the aspect of bias, my lord.
Yes. Anyway.
The bias, he who has initiated investigation has an interest in the outcome.
Yes. Cannot be judged in his own cause.
Judge cannot be judged in his own cause.
Yes, Dr. Mojika. How long will it take?
After we
Yes.
Okay. Just page.
Let them reply after 1 week.
Page. Very good. Lord, I had shown rule 202 of the Assam Rifles rules. My friend wants me to also show 204. Which page is it? 202 in the PDF. Tell me, otherwise I will not know.
Page 307.
302. Yes. 202. Yes, my lord. 348.
Yeah.
348 is authorized deduction, my lord sees that 202. And at 349.
347, 348, yes.
348, 349. 348 is rule 202.
Yes.
And 349 is the transition. 204.
Transition, right.
So whatever used to happen under the Army Act continues. That's the short point my letter friend wants me to point out.
204. Right. Yeah, take a date and after it will close it 15 minutes.
One date. 5th of May.
Yes.
5th of May.
5th of May.
Very good.
5th of May. May.
Or 7th of May.
It's a Tuesday, my lord. It's a Tuesday.
Yes. But I'll be returning on the 4th. I don't know, but you better keep it on 7th. Yes.
7th.
Very well.
Thank you.
I'm so glad. Well, my apologies for coming late. I got held up in the AP High Court.
Because we got a bit held up. Another thing.
Any mention?
Okay.
May I please, Your Lordship? Your Lordship, I beg to mention item number 34, Your Lordship.
1 second. Item number?
34, Your Lordship. Conducting counsel is unavailable, Your Lordship.
34 is what?
Lakshmi Joshi, Your Lordship.
Lakshmi Joshi?
Lordship. I have
You are
objection.
opposed?
Yes.
Yes.
Lordship,
We'll hear it.
Lordship, after a week, Lordship.
So we'll hear it. What is there? Where's your counsel? Yeah, you arguing the matter.
No, Your Lordship, it will be coming, Your Lordship.
Who's arguing that? Mr. Siddiqui?
No, S. Pandit, Your Lordship. Lordship,
Mr.?
I know S. Pandit, Your Lordship. After a week,
Mr.?
Your Lordship. S. Pandit.
Oh, yes, Pandit, yes.
Lordship, after a week, Your Lordship. Definitely. Lordship, the conducting counsel, he have some personal difficulty, Your Lordship.
I haven't seen the conducting counsel for a long time. I've seen only you. So
Lordship.
you're a conducting counsel in the eyes of the court.
Lordship.
Then
One week time, Your Lordship.
you argue the matter day after tomorrow. You prepare it.
1 week, Lordship.
You'll be arguing it, so 1 week.
Lordship.
Yes, mention has been made by MSB Pasa on behalf of respondents for some accommodation due to unavailability of the arguing counsel. However, this seems to be objected to very vehemently by MS, what's the name?
SD Sangma, Your Lordship.
By MS SD Sangma. Yes, who submits that the matter has been repeatedly adjourned. So, however, considering the prayer of the respondent, let this matter appear after 1 week, a fixed item.
Lordship.
Yes. Stop and also MS Ibipasa and the argue the matter
Lordship.
on the next date.
Lordship.
If the arguing counsel is absent.
Lordship.
Right?
Obliged, Lordship.
May I please, Your Lordship, I beg to mention item number 26 and 27. Both are connected matters. Connecting counsel is out of station.
Who's
I'm there.
no objection?
No objection.
Okay, yes. Yes.
Your Lordship, I beg to mention item number 39, Your Lordship. I have informed to the party also.
29?
39, my Lord, 39. Private respondent also, I have informed the DHDC also.
Yes.
Matter may come after 2 weeks.
Yeah, for whom?
For private respondent. Respondent. Private respondent.
Yes.
Much less, Lordship.
I'll pray for item number 30 also. My friend is the party member.
Yes.
Let come after 2 weeks.
No objection, my Lord. Much less, Lordship.
Please, Your Lordship. Lordship, I beg to mention item 31. Lordship.
What's this for today?
Lordship, it's hearing, Your Lordship. Seeking for accommodation. Hearing, Your Lordship.
No, what's it for today? Is there any specific order for instructions or for withdrawal by you?
Yes, there's a matter.
That long time?
Yes,
the delay in referring to arbitration?
No, Your Lordship. This is that contract, Your Lordship.
31 is that
not Eastern Police Academy, Your
There's
Lordship.
some dispute and there's some undisputed amount, so there's some disputed amount.
Yes, yes. What instructions do you have?
Lordship, we are awaiting
You take the undisputed amount and we close the case.
Lordship,
disputed amount you can run after it in another manner.
A week accommodation, Your Lordship. Let my senior be here physically, Your Lordship.
Once you stand means that case is not to be adjourned, so he's sending you to adjourn it. That's correct?
Practically.
Yes. Where's Mr. So many lawyers are here. S. Thapa, S. Kriyam, Oya there, S. Chanda. Yes.
Week's time, Your Lordship.
No, 2 weeks time. You take the money.
A week's time, Your Lordship.
Huh?
A week's time, Your Lordship.
2 days time.
A week's time, Your Lordship.
Tomorrow.
Day after tomorrow.
Lordship.
Mr. S. Kiriam, please the matter be adjourned to the absolute senior. So, however, as the pointed issue, it appears is only with regard to the receipt of instructions by the petitioner to the acceptance of the undisputed amounts, leaving the other amount to be contested. Let the matter be listed out tomorrow.
Similar to item 32, Your Lordship.
This is that long
Arbitration.
arbitration matter after it.
After 10 years, something.
Okay, after 2 weeks. Yes.
But 33 has framed some time.
Who's for the respondent? 33?
33.
You're for the appellant, yes.
Yes,
Operation.
no objection.
2 weeks, yes. Yes.
Please, Your Lordship.
Yes.
This, I beg to mention, a listed matter. This matter was yesterday, that Seema Bhattacharjee matter. He was not there yesterday, was not well. Today I tried to contact branch manager. He is on leave since Monday. There's a function, family function tomorrow. Lordship, I request this matter come up on Friday, Lordship, for his personal appearance, Lordship.
Then the order has to be recalled. You'll put an application for modification of the order, again modified by an oral prayer.
Because it's a short notice, I got hold of the order just last night.
See, look at the fate of the person.
I have a response, a very genuine reason.
And the way that your bank is conducting itself, it's you deposit the amount, you withdraw. You deposit.
There is a guideline here. I'll place that on Friday. It's only in the guidelines, because if there's an amount which is lying on lane, that lane has to be refreshed, and then it has to go on every 30 days.
And keep it again.
It's reverted back to the account.
That's a system.
I'll place that on Friday.
Which ways you take the liability of that 99,000? You withdraw it. Let them withdraw the amount and enjoy it. There'll be a cost to the
matter has to be heard first. When the state is also not clear. I'll place that on Friday. The reason,
unless there's some orders which are affect the bank very adversely, it seems your bank's not bothered.
But the thing is that if the bank
consumers have so much trust in your bank, and
the petitioner, apart from the petitioner, the family, almost the whole family has an account with a bank. They don't have a problem. It's only her. So in her situation also, everything has been done as per the guidelines. Also. There's nothing wrong. If you would have done anything wrong, then you would be liable.
You put an application then for modification.
Again, the application also has to be signed by branch manager. It will not be possible.
There's no other authorized person to sign.
There's no other.
Then someone else let him appear. Who's the second in charge?
At the moment, I don't have that instruction.
Yeah, then you make your prayer tomorrow. Or you send someone.
Otherwise, Your Lordship, he can appear by VC, not in person, if that is possible. If,
yeah, let him appear by VC.
VC, okay. Tomorrow. Thank you.
Yes.
Your Lordship, I beg to mention item number 19, Your Lordship. 25, Your Lordship. Lordship, I'm praying for 1 week's time, Your Lordship, because the conducting council is out of station.
It'll be 2 weeks. It'll be 2 weeks then, Your Lordship. This matter is in the closing stage.
The survey report is already submitted. You come for compensation for loss of trees and crop.
Yes.
After 2 weeks.
After 1 week. After 1 week or 2 weeks?
1 week, Your Lordship.
Yes. Yes.
Please, Your Lordship, I beg mention item number 29.
29?
Yes.
On whose behalf?
I'm from respondent number 1.
Who's respondent number 1?
The CMO.
What's your name?
Imadaba.
Lim.
Who's leading you in the matter?
Mr. Sindram is leading the matter.
Mr. Sindram?
Yes,
Who's Mr. Sindram?
Arki Sindram.
We have no objection?
No objections, Your Lordship.
Yes, 2 weeks, yes. Yes, after 2 weeks.
May I please, Lordship, I beg to mention item number 40 and 41, Lordship.
40, 41?
Yes.
My Lord, 40 to 45.
Yes, please.
Why are you taking time?
Mr. Esik is on leave, Lordship.
Who's Mr. He's on leave?
Yes.
Oh, and you are appearing
I'm appearing for 42 till 45. It's connected matter, Your Lordship.
with Mr. Hassan?
Lordship.
Okay. Take down Mr. Emra Marak in item number
40 and 41.
41 and
Yes.
41.
Yes.
No, 41 4041. Yes, and Ember Rahman. Ms. Hassan is not here. For items so present, pray for accommodation to absent arguing counsels. This matter of 2 weeks, yes.
Much obliged.
Supplementary list, item number 1.
May I be Lordship?
Yes, Mr. Kumar.
My Lord, this is the contempt petition, my Lord, against the order dated 15/3/2024, my Lord. Page number 12 and relevant person is at page number 18, my Lord.
1 year already gone.
My Lord, thereafter, respondent authority has preferred an appeal, my Lord, which has also been dismissed, and thereafter SLP was filed, which has also been dismissed, my Lord.
Yes, heard Mr. V. Kumar. Issue notice returnable in 3 weeks. Steps were taken. Not who has. Will accept notice?
I'll take it.
Yes. Also Dr. M. Mozika accepts with so and so is present. No further notice required. And 2 respondents. Yes, sir.
My Lord.
The name of. Yes.
2.
My Lord. Deep your Lordship.
Yes, here for the petitioner. Number 2.
May it please, my lords.
Supplementary is going on. Oh, sorry.
May it please, my lords.
Yeah.
My lords, here we're challenging the impugned letter, my lords, dated 17/3/2026. The issue here is very limited, my lords. What had happened, my lords? There was a IB proceedings, my lords, against the respondent number 3.
What proceedings?
Company my lords, insolvency and bankruptcy proceedings, my lords, IB proceedings against the respondent number 3, my lords. Now, I was a lessee of respondent number 3 at some point of time, my lords. Lease was cancelled, land given back, all that is over. Now that resolution.
Oh, you mean
has been
you are party also to the insolvency proceedings?
No, I'm not. I'm nobody.
Then how you
respondent number 3? I'm sorry, my lords.
You are the lessee of respondent number 3.
Yes, my lords.
They were involved in insolvency proceedings.
Yet, I'm sorry, my lords, I could not follow.
Number 3 was involved in insolvency proceedings.
Yes, my lords. The
what happened?
Proceedings were in respect of respondent number 3. I was a lessee, lease was cancelled, land handed over, everything is over. Now, my lords, the resolution plan of the respondent number 3 has also been approved by the NCLT. They say, my lords, the land to the successful bidder has also been given. Now, all of a sudden, my lords, on 3/7/2026, and I'll take your lordship straight to that letter at page 32, they are now passing some directions against me, my lords, which has prompted me to come before your lordships. If your lordship kindly have page 32. This is the impugned letter, my lords.
Yes.
Well, I'll read the entire thing to the directors of Millennium Cement, so and so. With reference to the subject cited by undersigned hereby informs you that in pursuance of cancellation of lease agreement in respect of 6 bighas of land leased to you by Virgo Cements, corporate debtor, the said lease stands terminated due to continuous non-payment of lease since December 23, which is clear violation of clause so and so. The clause is reproduced. Further, the resolution plan with regard to the corporate debtor has already been approved by the Honorable NCLT Guwahati bench by order dated 28/3/2025. Thereafter, successful resolution applicant needs to start the implementation of the approved resolution plan to revive the corporate debtor. That as directed by the Honorable NCLT on 21/2/2026, the plan of the corporate debtor along with 20 bigha of land was duly, my lords may kindly take note of, duly handed over to the successful resolution applicant. Strictly in accordance with the approved resolution plan. So whatever is the land of the corporate debtor, my lords, that's also been handed over. Now, your lordship may kindly see, in view of the above, you are called upon to vacate 6 bigha of land and remove all structures and assets of Millennium Cement, therefore, within 15 days from the date of receipt of this notice, failing which, if any structure or the asset belonging to Millennium Cement is damaged or affected during the operation revival of so-and-so is carried out thereafter, the monitoring committee of Virgo Cements Limited shall not be held responsible and liable in any manner, and for the same, an appropriate legal action shall be initiated against you for non-compliance without any further notice.
No, but this 6 bighas is not part of 20 bighas, which was part of the resolution plan. This 6 was not part of 20 bighas. The resolution plan is only 20 bighas.
It is part of 20 bighas. Land has been given back long back, my lords, because otherwise the resolution plan.
No. Just go easy. Now it says that as directed by the NCLT, okay, corporate data, 20
The
of land.
paragraph before the
Yeah,
the
duly handed
paragraph
over,
before
yes.
the ultimate paragraph, may kindly read.
And how duly handed over to
As
successful.
directed by NCLT.
Right. Just listen, please. Yes. Now you're called upon to vacate the 6 bigas. Is the 6 bigas part of 20 bigas?
No, my lords. No.
Okay. And then it's to vacate, it's not to hand over to the successful resolution applicant, but it's to vacate because if any structure asset belonging to you is damaged in operation of Work Simmons, so on.
Because that holds my plant, my lords. I am a separate company.
Yes. Heard Mr. K. Paul and the senior counsel with so and so. You should notice returnable in 2 weeks. Steps to be taken within 2 days. Stop the grievance of the risk petitioner, which is stated to be you're a company, cement company.
No, sir. I am a cement company, please.
Yes, okay. Is that an order has been passed by the respondent number? Respondent 1, whereby number 1 dated so and so, whereby
7/3/2026.
yes, dated 17/3/2026, whereby the petitioner has been directed to vacate a plot of land measuring 6 bigas within 15 days from the date of said notice. Mr. K. Paul and Senior Counsel has submitted that the respondent 1, apart from not possessing authority to issue the said order, the land of the petitioner falls outside the resolution process involving respondent number 3. The attention of the court been drawn to the impugn order, where it has been recorded that as directed, I recorded that as directed by Honorable NCLT on 21/2/2026, the plant of the corporate debtor along with 20 bigas of land was duly handed over to successful resolution applicant in accordance with the approved resolution plan. So he submits that the transaction pursuant to the order of the Honorable NCLT having been completed, there was no reason for the respondent number 1 to call upon the petitioner to vacate 6 bigas of land, which he submits falls outside the resolution plan. On hearing the counsel and examining the available materials, prima facie case has been made out for issuance of interim orders at this stage. Accordingly, till the next date, the impugned order dated 7/3/2026. This one, size.
3.
Yes, Mr.
May I please, your lordship. The petitioner is a laborer. So on 11/12/2025, he went to a resort nearby William Nagar. So what happened? There is some wildlife officer also there.
One?
Wildlife officers along with their staff was there. So they randomly fired in the forest areas. So as a result of which the petitioner got serious bodily injuries, my lord. Then on the same day he was admitted to William Nagar Hospital.
See, it's not shotgun.
Yes.
It's a shotgun. SHOT. He was shot. While also shot him with a shotgun. 25 pellets.
Yes.
Body.
Yes.
Yes. So what happened to the wildlife officer?
And then
Why did he shoot you? You were doing some illegal hunting.
Yes.
Yes.
Thereafter, what happened, my lord? They have given a written undertaking in the page number 23, and type copy is.
What's the condition of the petition now? He's recovered.
Yes.
He's recovered.
No, not yet, my lord. Because from the Tura hospital, civil hospital, they are referred to Guwahati for further treatment. Some of the pellet is still inside his body, my lord. So they have given undertaking on the same day to the elder sister.
Who has given undertaking?
That the officer who is doing in
Who shot that person?
Yes, this wildlife.
Where's the
office.
undertaking?
Yes, in page number 37.
There's no police case registered.
Huh?
There's no police case registered.
I do not know, my lord, because they have registered or not, but they have not taken any action, my lord.
No, but that means you said you were shot by a wildlife officer.
Yes, yes.
With a shotgun.
Pellet bullet.
Pellet.
It's the type of it's
Yes.
the
But he received
cartridge.
injuries.
Yes. Yes.
Yes, I am
And so
coming
you
to
shot and then with undertaking given.
At page 25, Your Lordship.
Yes, page number 37.
25
copy.
Or 27 is the typed copy, Your Lordship. On the face of this undertaking, negotiation as it is called, Your Lordship, here, doesn't seem to be an official document, Your Lordship. There's no letterhead. So he has made the
You mean to say that there was compromise? Someone shot somebody and they compromised outside the court to pay for the treatment and that's over?
No, my lord, they have not.
Their only grievance is that the reimbursement has medical reimbursement
even then, I mean,
even
if a
their
wildlife
lordship.
officer
But this
has
is what
shot a
is their
person in
prayer.
a forest. You mean there's nothing registered, nothing, no even wildlife
There
offense,
is no
nothing.
pleading on that, Your Lordship. Except that there was a negotiation between this.
No, how is that possible? Forget about negotiations.
So, no, Your Lordship, I am just saying
you
that.
talk to the family members like, okay, fine, or you injure somebody, you say, I'll pay for the medical reimbursement
and that
chapter
matter,
closed.
it appears so from the pleadings here.
So you get instructions.
We'll get instructions,
Mr.
Your Lordship, but yes.
Consultation issue notice. MS T. Yangi B. Learned AAG with so-and-so is present.
1 to 4.
Yes, must be have respondents
1 to 4.
1 to 4. Notice to issue respondent 5 and 6 within 3 days. Stop.
Was this officer has been made a party by name, Your
Case
Lordship?
concerns an incident wherein a wildlife officer had shot the writ petitioner with a shotgun, wherein a shotgun leading to the injury of the writ petitioner. Stop. It is submitted by Ms. Azarika that there was an agreement that the concerned officer who had shot the writ petitioner would reimburse a medical treatment. But however, the same has not been honored.
Has not been done.
Yes. As such, he prays that this is all stuff. This court on hearing the counsel and also examining the materials finds it strange that in such a grievous incident, there are no other accompanying materials to show whether any case has been registered or any action taken by the respondents. Yes. Just after 2 weeks. Yes. How is it possible? He happily gets shot and says, all right.
No.
Must be doing some illegal hunting. Yes.
My lord, in this matter, the petitioner is the Shnat Ring, represented by its Sardar. Shnat, his Sanat is at page 11.
Okay, yes.
And then I'm aggrieved here in this matter, my lord, I'm aggrieved by the impugned letter dated 27th March 2026. It's at page 14. Translated copy is at page 15.
Yes.
Your lordship, here I'm aggrieved because why the district council passed this impugned letter directing the performer respondent, the same of Makhirim, to direct the third party to convene the Darbar Pulun in Shnat Ring. This is against the customary practices.
Now, who's this number 5?
Number 5 is a private respondent.
Is it number 3?
How
can your district council direct that certain Bakhra holds a meeting?
Lordship, because there was an election dispute, but this case has
Who is
become
this Milimpada?
This case has become infructuous, Your Lordship.
Infructuous, whatever. What can this council order give such orders?
Your Lordship, he is the Bakhra.
Person from the
No, Your Lordship, he is the Bakhra. He is administrator of the
No, it's not possible. The
question
you can't just dictate the CM. It's within the authority of the CM to convene a darbar. Who is the council to go over and above?
Your Lordship, this matter has become infructuous.
The equation of infructuous, my lord, does not apply with the lapse of time when the action itself is void.
Without jurisdiction, yes.
Yeah, without jurisdiction, it's void.
Mr. What's his name? Doctorate.
PA Doctorate.
Yes, the council petitioner is MSPS Nongri. Is present except notice on behalf of the respondents number
124.
124. let notice issue respondent number 5 and 6 within 2 days stuff. The issue that has been raised by the petitioner is with regard to the impugned direction of the district council respondents, whereby directions have been issued to the scheme of crime respondent number
6.
Performance number 6.
Respondent number 6.
To instruct the respondent number 5 to convene the Rotpulan of Shillong Ring.
On the 31st March.
Is submitted that is not understood as to under what provision of law or under what authority the council has issued this, has issued the impugned direction. He's just 5 is who is he?
5 is a private party.
Who is a private person? We should stop. Like MS PS Nongri submits that the matter since within the structures in view of the fact that the direction was for convening of the Darbar on 31st March 2026. However, this court, looking into the manner of exercise of power by the council respondents, especially in the matter jurisdiction, deems it fit to take up the matter for consideration. Yes, list up to 2 weeks. Yes.
Much more.
Done. Some lesson should be given, I think.
Your Lordship, he is not a stranger, he is the Bakhra of the Raj, Your Lordship.
He cannot
be done. Bakhra of the Raj, but the thing is that you can't direct the CM to say this number A, number B, to hold a meeting.
Your Lordship, because
they should be aware of how the hierarchical system operates also.
there is a law and order situation at the Shnara, Your Lordship. That is why it is important to...
My Lord, without being show cause, they cannot...
This is not the first order in our council. Very unfortunate. Very unfortunate that whoever's in power, they have no idea about how the systems operate. If you leave it to people like you, who are experts now, to advise them, it should be under good advice. Otherwise, you'll destroy the whole institution. Yes.
Number 5, my lord. The petitioner is aggrieved that the benefit of third MACP has not been granted to him due to lacking of ACR, my lord. That ACR has not been communicated to him, my lord. So
for which year?
I am praying for that has not been given to him, my lord.
Yes, sir. Mr. V. Kumar, issue notice. Total Musica with so is present. No further notice and respondents list after 3 weeks for instruction. Affidavit, yes.
6.
My lord. Item number 6 and 7, my lord, the disability lump sum prayer, my lord. After the completion of 30 years service, notice, my lord. Deeply lordship. 6 and 7, my lord.
Daily list item number 1.
Yes. You've been paid subsistence allowance.
My lord, so far it has not been released, though I have put up my representation, my lord.
No, but last time they made a submission that where's the office order?
My lord.
You given a copy to him?
I've already given them a copy, Lordship.
What instructions do you have?
My lord, here, as per rules, my lord, I'll have to file my representation claiming the subsistence allowance, my lord, which I have done, my lord.
See, it's already allowed to you.
Yeah, yet to be disbursed.
So, we'll close the matter now.
No, my lord, that is not the issue here. The core issue is something else, my lord.
What's the core issue?
Departmental proceeding, my lord.
My lord, before my friend starts, if I may submit Lordship, because their primary prayer is to set aside the impugned suspension order, including the intended departmental proceeding, Lordship. Lordship, I have to submit my Lord herein that the departmental proceedings are complete.
I have no knowledge about that. Which is why, my lord, which is why, my lord, with all due respect, my lord, it was being dragged. And I had been repeatedly making a prayer, my lord.
Mr. Argurung submits that though by the communication dated, office order dated 15/10/2025, the subsistence allowance of the petitioner has been released. has been allowed to be drawn. He has no instructions as to whether the same has been disbursed with petition.
No, it has not been disbursed. We have just put up
He has
the
instructions
application.
whether it's been disbursed. Yes. We're not seeing any affirmative. He further submits that as the matter concerns the department proceedings,
My lord.
also pending against the petition, that the matter be heard. Yes. And this is the matter after affidavits have been exchanged.
Lordship.
My lord.
After 2 weeks for hearing, the copied office order is taken on board and made part of the record.
My lord,
You don't have extra copy.
my lord, we'll make an extra copy, Lordship. My apologies, Lordship.
Deeply obliged.
Yes.
2.
In this matter, my lord, I have been instructed that we want to withdraw this with the liberty to approach the appropriate forum. My lord.
Yes, sir. On the prayer list, the SD for withdrawal with liberty to approach appropriate forum. The matter stands closed.
Well,
withdrawal. Our liberty as prayed. Yes.
Try, Lordship.
3.
Yes.
The item 3 is that election petition.
Ready.
Are going to give us on the order. Yeah, Malaj, I am okay. If my friend can start, Malaj, I can respond.
You take it up at 2 o'clock
Okay,
then.
just-
At 2:15. Yes. Call other matters first. 2:50. Pandey. Yes.
Yes, Malaj, may I pray your lordship then have it on Thursday, Malaj, if not inconvenient.
I was just waiting for that place to come.
Malaj, the only issue is that because
Will you be available personally? Physically, sorry.
So in that case, plus I will be requesting for 30th, plus, because I will be there physically on 30th.
30th, this code won't be there. Yes. You have to be on 28th.
28th, plus,
28th.
28th, plus, 28th.
Very good, Malaj, 28th.
Yes.
4.
May I please, your lordship?
Yes, Mr. Pasquier.
Your lordship, today the matter has been fixed for the appearance of respondent number 6.
You're appearing for number 6. Mr.
was done for the state
I'm
one.
appearing for the petitioner.
Yes. This is the BEC matter.
No, my lord.
The
review
matter pertains to, like, I'm seeking for a leave to defend.
Leave to defend?
In a
Its pensionary benefits were released to one of the parties, and the review petitioner claims that he was not made a party and certain relevant facts were not brought to the notice of the court.
despite of the fact that the succession case is still pending before the Ampati court, your lordship.
Won't you file regular appeal and take leave to appeal?
Very limited grounds on review.
Very limited grounds.
Lordship.
But review, we can't open the whole case, Mr. Pasquier. You take a call.
Yes, your lordship.
Yes, again, today, also there's no appearance, we have number 6 of Mr. Pasquier. So please allow to obtain instructions on the matter, just after 1 week. Please.
Deeply obliged, your lordship.
5.
Yes, lordship. I'm filing this rejoinder during the course of the day, my lord. It's already been filed, I think. Today.
Yes, Mr. Deputy said, sir, the general will file the course of the day, list the matter after 2 weeks for hearing.
Lordship.
Must
Yes, lordship.
6.
Lordship, here in this matter, the respondents have filed the affidavit, Lordship. I'm praying for 2 weeks' time to file rejoinder, Lordship, to the affidavit.
All respondents, any part of respondents?
Lordship, they are the main contesting respondents, Lordship. State, Lordship, PWD department.
Mr. External pre-response allowed 2 weeks time to file affidavit for rejoinder to the evidence filed by the state respondents.
7.
Yes.
Lordship's, in terms of Lordship's last order, petitioner was directed to serve a complete
Yes, sir, complete copy. Yes, sir.
Yes.
When will you file affidavit, Mr. Khanulang?
My lord, may grant 2 weeks time, Lord.
By today?
Not 2 weeks time, actually.
Lordship,
Milord, the issue is, Milord, the issue, if I may submit, Milord, issue is, Milord, the issue is, Milord, in this case is that the allegation of the petitioner is, Milord, that the land which has been acquired by the authority, encroachment has taken place on his land. If your Lordship will see the affidavit, Milord, if your Lordship will see, and NHI DCL is the main party. And page 39, if your Lordship will kindly have page 39, Annex 3, Milord.
Next year.
Annex 3, page 35.
Are they represented here?
Yes, Milord. NHI DCL is party.
Who's appearing for them?
I'm appearing for
with Pandey.
Yes, Lordship.
You won't file affidavit?
File affidavit altogether. Item number 7, 8, 9, 10, Your Lordship, pertains to same subject matter, Your Lordship. Will be filing the affidavit.
24 also,
No, yes.
Will you be filing affidavit in this coming days positively by
all of these? You have to file individual affidavits.
Yes, individual.
Yes, Mr. RK General, when you file affidavit.
So, Milord, basically,
We put after 2 weeks, whatever you want to put an affidavit. Yes.
Yes, Milord, because there is no affidavit may not be required, Milord. I have seen because there is no allegation.
You better put an affidavit because sometimes.
All right, I'll do that. I'll do that, Milord.
Even if your stand is, your stand is clear, there's no claim against you, we put an affidavit.
Yes.
It'll go on record.
I'll do that. I'll do that.
Yes, you are appearing for? 24.
24 for the state. Item number 2.
Yes, Mr. H. Karwan, Mr. Archival General, not his matters, no, individually. Praise for and Mr. Majao.
S. Majao on behalf of S. Pandey.
On behalf of Vice Mr. S. Pandey for NHIDL respondents. Number 4 allowed further 2 weeks time to file affidavits. Yes. And number 6, ASC Infratech. They've been served.
Yes, my lord.
However, there is no appearance on behalf of the respondent number 6. This is in item number 7. And then other matters, other items.
7, 8, 9, 10 and 24.
ESC Infratech SIM is there.
No one appeared for respondent 6.
Okay, up to number 10. Then 24, record the name of additional AG instead of Dr. General. Yes.
Hello.
11.
Oh, well, I filed my affidavit. I've served a copy of it.
Lord, I'm appearing for respondent number 1, 2, 3, and 5 and 6, my lord. I will require some more time, my lord, to file the affidavit, my lord. That is
why
I've not been able to complete the affidavit, my lord.
4. You already filed. 7 filed.
Yes, my lord.
9.
For 9, Lordship, we're just waiting the affidavit from the state.
Who are you?
I'm the
village.
No.
What is the matter about?
Proposed landfill, Your Lordship.
Landfill.
Landfill.
You are opposing it?
Yes, Lordship.
Or supporting it?
Yeah,
opposing it.
You're supporting it?
Yes.
It's in my village.
They are the beneficiaries, my lord.
Then what is your locus?
Lordship, there was a public hearing which was conducted, and
you're not
we were not allowed participation.
How are you affected?
Because we are the
landfill is the village. Huh?
We're the neighboring villages, Lordship.
Not from.
What is your main objection to the landfill?
Just that we were not allowed participation in.
We are challenging their maintainability.
They're from different village, my lord, not from the same village.
Not only village, my lord. There is an unregistered body who is before this honorable court in a writ proceeding.
Oh, then anyway, you file affidavits. Yes. Mr. N. for 1, 2, 3, 5 and 6 praise funds allowed further. 2 weeks time for affidavit. Similar prayer by whom?
Respondent 9.
Number 9. Yes, list after 2 weeks.
12.
Please, your lordship. Lordship, I'm praying if this matter may be taken up after 1 week, lordship. The DSGI, due to some emergency, he had to leave.
Some
emergency, lordship, he had to leave. Since the petitioner was supposed to make some
submissions regarding the instructions which we've provided, Lordship.
What is the matter about Mr. from
regarding remonstration, service matter, Your Lordship.
It is after 1 week on the prayer of Ms. Merchant.
13.
In affidavit in opposition has not yet filed, my
I'm
lord.
praying for some time, Lordship.
File the course of the day.
No, Lordship, I'm praying for some time.
When is the matter 5-6? 25, last part.
My lord.
Lordship, we've
My lord.
recently received instructions, Lordship.
Yes, sir. Further 2 weeks time allowed to the respondents on their prayer. Expected next date, effort should be on board. Yes.
14.
My lord, item number 14, we have received the affidavit in opposition, my lord.
Yes.
So, for the 3 weeks time may be granted to file the rejoinder, my lord.
You already prayed earlier on. Yes,
My
further
lord,
this time has
the
prayed
second-
allowed for rejoinder. Yes.
My lord.
Yes.
And, item number 15 and 16, affidavit is also waited, my
I'm
lord.
praying for some time, Lordship. Those matters well. I'm praying for some time.
Instructions are received.
We've received, Lordship, recently.
Speak up. Speak very quietly because you haven't filed the affidavit. Don't be so softly. Speak up. Yes. We can hear you. Yes, that's prayed further 2 weeks time allowed. Yes.
Highly appreciated.
My lord. 15 and 16, my lord.
17.
In 17 as well, we're supposed to file an affidavit, Lordship. I'm praying for some time in this matter as well.
Who's there for the petitioner?
I am for the petitioner, Lordship.
Yes, as prayed. Your name is B. Sharma. What is
Yes,
your name?
Lordship. B.
Yes, you
B. Sharma.
Petitioner as prayed further 2 weeks time allowed for affidavit. Yes, yes, there's the after and so on. Yes.
18. Deeply applies.
Lordship, in the last occasion, the counsel for the respondent had paid for time to file their objection. So it's a transfer petition, Your Lordship.
Where she was here just now? Who? She was here just now. That Esar Marak, she was here just. Soul, where she was, she is the person, right? She was also appearing the other matter.
Not very much.
Yes. Though on the last occasion, MS SR Marak had sought time for filing affidavit on behalf of the sole respondent. There is no appearance on behalf of there is no appearance to the behalf of respondents. In interest of justice, this after 1 week affidavit. Yes.
Much obliged.
19.
This is a contempt petition, my lord. What happened, Your Lordship, in this case? There is the question of regularization of 171 days. So, university initially taken a decision not to, asked her to leave. The matter reached my lord division bench. Then division bench said reconsider it. We have reconsidered and we have regularized. And I have submitted on last occasion a copy of the resolution of the EC, my lord. Matter can be closed, Your Lordship.
Yes.
Lordship, I was supposed to come up with instruction, or Your Lordship, in this matter.
No, my lord, she has in fact written a letter. She has written a letter to us. Yes, please. This is her letter, my lord. She has acknowledged.
Yes. As per the executive consideration, the period from May 28 May 2020 to 30th October 2020 appears has been regularized and treated on duty. As such, nothing remains further consideration. The contempt application same is closed. Yes. All right.
20.
Because the union has filed their affidavit, we've received it. I'm just praying for a week's time to file a short rejoinder, my lord.
The admission part?
Yes, my lord, yes.
The seat still there?
They filed a rejoinder, well, it's a composite rejoinder by 2 and 3. Nothing much really comes out of this. In fact, some other statement that they made towards the end of the rejoinder is not entirely correct. So I'll just place a quick, very short rejoinder to this.
Yes, Mr. S. and please for 2 weeks time to file.
Let's have it on the 30th then. 30th.
30th, when this court won't be there.
So on the 29th, will it? I'll file it before that. 20th.
Yes.
Lordship.
Yes, allowed 1 week's time to file the rejoinder. Yes.
Lordship.
Yes,
Obliged.
21.
Lordship, in this matter, I am praying for time. Instructions we received very recently.
Well, I was directed to file an affidavit. My affidavit is ready, man. I will file it today itself.
There's an order on 9/3/26, Your Lordship. The petitioner is supposed to file an affidavit.
Yes, my affidavit is ready, man. I'll file it today itself. Positively.
As paid by the parties for the 1 week's time allowed for respective affidavit. You have to file affidavit also, right?
Yes, we'll have to file our counters. Obliged.
22.
No, importantly, Mr. S. Day today submits that the affidavit allowed by this court by order dated
9/3/26.
9/3/26 will be filed within 1 week. One would file a course of the day. Course of the day. Course of the day. Respondents for it to file the jointer the same within.
Not rejoinder, my lord. It's an affidavit just to bring on record the documents.
We'll file a counter affidavit, Lordship.
We'll file a respondent file counter affidavit after.
22.
Just after 2 weeks. I'll let you
Send one of them. Prepare it now.
Wait, please, Your Lordship. Your Lordship, I'm praying for some time on behalf of respondents 1, 2, and 3.
Rule number 4. Number 4 is whom?
Principal Accountant General, Lordship. Principal Accountant General.
Where is that EB Pasa? Yes. Why didn't appear last time also? No, nobody appeared.
Lordship, I have seek instruction of you to receive instruction, Your Lordship.
I can't hear you.
I have seek instruction of you to receive instruction, Your Lordship.
Will file affidavit or not?
I'll be filing, Lordship.
Yes, respondents is in for 1, 2, 3 and EB Pasa for 4, pray for out for the 2 weeks time to obtain instructions to file affidavit. Yes.
23.
It is a matter of the freezing of bank account, Your Lordship.
I have received an instruction dated 20th/3/2026. Yes, I was handed over, my lord, to corridor of the court. So here, my lord, they are saying I'm permitted to read, my lord, the brief of the case, my lord. Bank Fraud Risk Management Department has placed a debt freeze and lien of 15,000 on account.
What are you reading?
This is a letter, my lord, that just now they have given me a copy.
Who has given you? You?
The bank, no, it's from the bank.
I haven't received
From the bank. I'm the bank, my lord, Bank of India.
Bank of India?
Yes, Bank of India. But they are saying, my lord, they have not defreezed it, my lord. It hasn't freezed from the from their there is a fraud risk management department, my lord, within the bank. Of the bank.
From the central office.
Yes, my lord. And from the central office, they have defreezed it an amount of 15,000 in compliance with the notice dated notice under section 94 of BNSS.
You file affidavit then?
I will file an affidavit. Small.
What about the other respondent?
We are the state, Your Lordship. State has got nothing to do with it.
Three respondents. State is appear, Your Lordship.
No,
Respondent number
Kerala?
2. No, they have not appeared, Your Lordship. They have not yet appeared.
It's no such address of what Pathanakot.
Kerala police will be very much important.
No. This is not the.
Correct.
I have to take fresh steps in that case, Your Lordship.
That's not correct address, I think, Mr. Majab.
We'll take fresh steps, Your Lordship.
Where do you get that? Where do you get the address from? With regard through, if you're flying through DGP, then it'll be in the capital only.
Yes, Lord. We have checked it online, actually, Lordship. We couldn't find the address. We have just tried to verify it online. So this was the address which has been provided.
But the crime originated in this district, Alappuzha.
Yes, ma'am.
Yes, the complaint is from.
Then you'll have then you have to change the party should be officer in charge of so and so in this or SHO whatever of this cybercrime cell. Pathanakot is Mr. S.A. Majau please be allowed to take fresh steps on respondent number 2. by no, Mr. The notice to respondent number 2 has written unserved due to a wrong address. Mr. S.A. Majao prays that he be allowed to correct the address and name of party in the cause title and to take fresh steps on respondent. So respondent number 2 prays allowed stuff. Next para, Mr. S.D. on behalf of respondent number 3 submits that he has received instructions and prays that he is allowed to praise the same or we have affidavit file. Just up to 2 weeks. Yes.
You're just a formal party.
And you record your presence for 1 week.
Hearing. Supplement 8.
This is the matter, my lord, where yesterday the matter was heard. Only, my lord, an order, my lord, that they should process my pension papers. And I'm claiming the pension. I am an adopted daughter. They have given me that these are the documents which is required to be furnished. I have furnished to them. And I have also placed on record by way of a rejoinder before this honorable court those documents which has been. You're the only party. State is.
Lordship, page 40 of the writ petition, Your Lordship. Lordship, here she clearly mentioned she is the adopted daughter, Your Lordship. Lordship,
adopted daughter, but in the birth certificate, it's shown as a natural father.
Lordship, it creates a confusion. And here she clearly stated, page 40 of the writ petition, Lordship, on close perusal, it is observed that late so and so adopted a daughter, namely Cherry Tangme K. Sangma Amarak, and after his separation from his wife, his adopted daughter, Miss Cherry Tangme K. Marak, look after her father, late Habitson Marak, till the time of his death with love and affection, just as his own biological
Now you obtain a birth certificate after he died.
Probably, my lord, it appears.
Then how can you write this is natural? But even then, he's not the natural biological father.
It's not a but it's not that anywhere we have written.
But then you.
Lordship, I have seek instruction yesterday, Your Lordship. It was informed to me that they can't move forward without any declaration deed or some anything, Lordship.
Even adoption deed?
Your Lordship.
Now,
it should be during subsistence of his service, Your Lordship.
See, yes, adoption has to be substance of service.
Your Lordship.
That means a person who retires can't adopt anybody else
Lordship,
and make them beneficiary.
Lordship, right before he passed away or anything, because he was passed away during the service, if I'm not mistaken. During his service, Lordship.
Even if post-retiral,
Lordship,
spouse, children born from a spouse after you retire, they entitled also.
They are also entitled, but Your Lordship, any direction from the court, but I was instructed that they should submit
adoption deed.
Your Lordship.
Now, my lord, when my father is not there, how an adoption deed can be executed?
Lordship.
Only I can give a declaration.
Lordship.
Moreover, my lord, there is in the succession certificate, my lord, in the succession order, my lord, they have admitted.
Lordship, for LTA pension, Lordship.
For
LTA pension for a period of 5 months.
Not for family pension.
Yes, not for family pension, Lordship.
That means you have to go to the succession court again to get family pension. Declaration the adopted daughter. Or we can shortcut the process. Only thing is that how in the birth certificate adopted daughter showing the father, natural father.
Lordship.
Let's see that. Vatera 215. Yes, other hearing matters also. Yes. Yes,
Lordship.
Some reservations are at 215.
That item number 35, that Bijni complex, my lord, that matter the government and Nehu is sitting today. So, my lord, it may come up after 2 weeks. Only the interim order may continue.
38. Yes, 35.
Item 38.
35. Parties, Mr. S.N. on the petitioner. 38, sorry. Mr. S.N. Learned Counsel for the petitioner. Mr. Endishulai, Learned AG on behalf of respondents, submits that the matter still be considered by the parties at their level.
So we are meeting today.
Pray.
Will come after 2 weeks, Your Lordship, because if settlement is there, then
prayer allowed. This up to 2 weeks. Interim order when shall continue.
Lordship. With regard to item number 28, Your Lordship, we were supposed to file additional affidavit. Bring on record 28.
Disregarding
We were supposed to file an additional affidavit to bring on record some documents which had been allowed, and so we are filing it in course of the day. Just that.
Yes.
Lordship, we've received the affidavit.
What is your name?
Beeling Dog.
Billing Daw is 28.
Rajiv Jeffrey Malhotra, Your Lordship, regarding promotion and seniority.
Yes, MS T. Yangi B. The AG submits that the affidavit allowed to be filed with this court will be filed in the course of the day. So, MS Billing Daw, who is present on behalf of the petitioners, submits advance copies already been received. Yes, this up to 1 week.
I acknowledge Lordship. Lordship, item number 35 to 37. Connected matters, Lordship.
Which is this? Come politely, you don't find?
His Lordship, I got the detail of the similarly situated personnel who received the disability lump sum compensation.
You give them a copy and we will examine next year. It's MS East Nandram today has submitted that they have the petitioners obtained copies of
the detail of the
details
amount
of other
deposited in
similar
his
personnel who were granted disability pension. Copy of the same made over to the
Lordship disability lump sum
court and made
compensation.
over to the respondent stop. MS Ember Chang, principal to obtain instructions. This after 2 weeks. Yes. Let's say 215 or 230. I forgot.
215 it was. It's okay, my
Oh.
lord.
Now doing some other work.
My lord, here, my learned friend has agreed that since there is an absence of the law, the amendment is not there about a second wife, or my lord, the children who are born out of the wedlock, maybe a second wedlock, my lord, and after post-retirement, my lord. Then that definition, my lord, that amendment will be required. But it has fallen from this honorable court, where in one of my case, Hosila Sangma, my lord, if my lord recollect, Hosila Sangma, my lord, where my lord has passed an order that they are entitled for the pension. Now, if the second wife is entitled post-retirement, in that case, my lord, what has happened, that a man was asked in Garo customary law, my lord, after the death of the first wife, a second wife was given. Yes. And now she is getting the pension. She is getting, my lord. So, if order falls from this honorable court, my lord, that will be better, my lord.
Adopted daughter can get also.
Oh, yes, my lord.
Because
Yes.
the only remaining missing document is the adoption deed, your lordship.
Now, only the adoption deed, only I can make a declaration, my lord. If that can be taken into consideration, my
That's
lord.
the issue, lordship, because I was informed, I was instructed that the adoption deed should be during the when he was alive and assistant of the service. So, direction, lordship, that's the only thing.
Yes. How old is the lady now? Or the
Lordship,
girl?
36.
36, I think.
36, lordship.
35 she was when we were 2024. Now, my lord, she will be 37, my lord. The difficulty, my lord, she cannot go and search for a different job also now because of her uncle, the brother of the father, who is having some problem, my lord. 38.
Now you're saying that under the amended rule she is entitled to get?
Yes, my lord.
Let's see the 48 1B.
Yes, my lord.
Where is that quoted?
Yes, my lord.
Well, I don't like to keep these pension matters pending. No? Where is it in the petition?
My lord, may kindly come to para 4 of my writ petition, my lord. There I have stated my lord, may kindly consider if I am permitted to read, my lord. The petitioner begged to state that her father, late so and so, was serving the said post and he had rendered unblemished and dedicated service in the said post and had thereafter retired from the service in 2016, my lord. However, unfortunately, he soon met with his ultimate demise on 2017. And that certificate was issued in 2017, my lord. Now, my lord, may kindly come to Annexure 1, page 26A. The birth certificate which was given to me, my lord, is 2012. It is not the case, my lord, post-retirement. I was adopted pre-retirement, my lord. But my learned friend was trying to project that post-retirement.
Lordship, the issue is if the birth certificate was obtained through a court order, in the remarks in the portion, remarks portion, it will be mentioned a certificate number or something. However, we do not know how the certificate was obtained, Lordship.
Just by issued by a competent authority.
Competent authority.
However,
they have not challenged this.
We have not challenged it. The only issue is we at present, Your Lordship,
kept quite adopted, no one around one.
And my lord, may kindly see 26B. This is the caste certificate which has been issued in 2009, my lord. There also my father's name was reflected.
Lordship, we have no objection, Lordship. The only issue is the adoption deed of Lordship, if any direction.
We can make a declaration from the petitioner itself, my lord. The father cannot give a declaration now, my lord. He is no longer there.
How come even in the school also, see,
Yes.
2008 also,
2000, yes.
daughter of C.
Yes.
Son Marat.
But as per the version of the petitioner, my lord, like from the childhood she is with that family. Now she got, my lord, known from her relatives that she was adopted. That is why that declaration was made by her that I was adopted. But she is not certain that whether she was adopted or biological father. And no father will say.
There's no other siblings.
No, my lord. And no father will say to the children that you are not my adopted. It will be very painful also, my lord, to say that. And my lord, may kindly see, after the death, my lord, means after the retirement, after the death of the mother, my lord, the daughter has taken care of the father, my lord.
Okay, fine. But then only thing is that it's really a technical aspect. You see, it's not
Yes,
it's a question of a point to be argued in law or something.
My lord, my lord.
This is the technical
Correct,
thing.
my lord. There's
only how
no
do we
dispute. Yes, my lord. There's no dispute about that, my lord. Now,
you take down then. Yes, the petitioner, who stated to be the only daughter / legal heir of one late Hebit's son Armarak, Hebit, Hebit, S-O-N Armarak, who was an employee in the office of the District Agricultural Officer, East Garo Hills. In a grade 4 post, bracket Chokidar, and who had expired on 10/5/2016. Is before this court praying for grant of family pension in her favor. Mr. S.D., counsel of the petitioner, has submitted that the petitioner, who is unmarried, is the adopted daughter.
Appears so.
Is the adopted daughter of the deceased employee, and that the date of adoption could no longer be ascertained, as it had happened when she was in infancy. Top. The counsel, however, has taken this court to birth certificate, the caste certificate, and also a birth certificate dated issued on 29/2012, a caste certificate issued on 21/5/09, and also a transfer certificate, a school transfer certificate, dated which one? It dated 18/12/2008, wherein the deceased employee has been named therein as the father of the petitioner. The counsel also submitted that with regard to other terminal benefits, where is that section?
Page 39, my lord.
With regard to other terminal benefits and entitlements of the deceased employee, a succession certificate had also been granted to the petitioner, for which she received rupees 9,49,223 being the leave salary, GPF and DCRG. So, however, he submits in respect of the family pension for which the petitioner has been application, the same method been considered. Where the rejection? The same has not been considered.
That is on page 52, my lord. 52. 52, my lord. That's 000, my lord.
Yes. Yes, I will consider as much as the respondent number, senior accounts officer, this accounting general.
Seven.
Number 7.
8.
Response 7 and 8. And by a pension payment order dated 16/01/2024 has noted that there is no family pensioner, and as such, no family pension is payable. That council submits that it appears that the denial for grant of family pension is due to the fact that she has stated that she is adopted but has not come up with the requisite documentation to substantiate this fact. He therefore prays that directions be issued. He therefore prays that
only thing, my lord, if I can add, my lord, the documents which they have asked from us, my lord, to produce, we have produced all the documents, which is also enclosed in rejoinder, my rejoinder, only the adoption deed, my lord.
Yes or no? Last sentence. Huh? Before the response section 7. So we submit that. Otherwise, all other documents as required have been submitted to the said respondents. So he therefore prays that in view of the circumstances, there is no impediment to response 6 and 7 to consider the grant of release for pension to the petitioner. Next paragraph. MS EB Pasa, Learned Counsel for the response 6 and 7 submitted that the with the affidavit.
7 and 8, my lord.
7
and 8.
7 in. You for?
For 1, 2, 6 and 9, my lord.
Yes, MS EB Pasa. You for?
1, 2, 6 and 8, my lord. Oh, sorry, 9. My apologies. 1, 2, 6 and 9. 1, 2, 3, 4, 5, 6 and 9.
Yes. I submitted that. What's your submission?
Lordship, we are the only
That the response unable to process
Lordship.
the release of family pension in view of the fact that under the Mega Civil Service pension rules, the petitioner will be covered even in the second category of the rule, right?
Lordship.
And neither has the petitioner furnished a legal adoption deed as declared in an order dated 27/9/2018 in the matter when the succession certificate was granted. Therefore submits that the writ petition being barred by technicality,
Lordship.
yes, cannot be granted the flying pension. Yes, Mr. Rinja, what do you have to say?
Lordship, so far as the response concerned, my lord, we have no objections. Motive pension is the only difficulty is regards to that birth certificate, my lord.
Yes,
Any orders may be for me, lordship.
Mr. J. Rinja, appearing for the state respondents, has submitted that the state respondents themselves, who are the employers, have no objections if the family pension be granted to the writ petitioner, and that be granted subject to not subject to, even in absence of the adoption deed, in as much as the fact that the not like that, Mr. Rinja said that they have no objection to, and then have to the writ petitioner. Where's your affidavit?
You filed it on the 7th of November.
Yes,
There are 9, my lord. I have stated this.
But they have no objection if the attorney, and in this regard, had directed the respondent number 6 is whom?
State Lordship.
That's you.
The district agriculture officer, my lord.
What commission is this? I don't understand affidavit, send this letter, got no compliance. Makes no sense. What should be the meat of the matter we answer? Like it is a statement, you write a statement, you start with denial, but then you address the facts that have been placed by the petitioner, or like that. Not running around in circles. So, no? But has also echoed the submissions of the learned counsel for this one, 6 and 7 and 8. So you're 7 and 8, right?
7 and 8 Lordship.
That the same could not be extended due to the absence of a proper adoption deed. This court, having heard learned counsel for the parties and also on perusal of the available materials in the report, has noted that the fact that the writ petitioner is the legal heir of the deceased employee by adoption, otherwise is undisputed. Stop. The documentation that's been provided, especially the birth certificate who issued in 2012, was during, he was still serving at the time.
Yes.
Was during the period when the deceased employee was still in service. So also are the other documents, that is the caste certificate and the transfer certificate, wherein deceased employee has been, wherein
the deceased employee has been shown as the father of the writ petitioner. The only hindrance, therefore, is in the hindrance, therefore, is due to the whether order of the is due to the
Page 40 of the writ petition.
page 40 is due to the
page 40.
yes. Absence of adoption deed, inasmuch as the factum of her being adopted has been recorded in the order dated 27/9/2018, passed by the Additional District Magistrate while granting a succession certificate to the writ petitioner for the other paternal benefits. So, a perusal of the order 27/9/2018 would show that by judicial order, the adoption of the writ petitioner by late Hibitson Armarak was recognized. Also, this seems coupled with the fact that there's been no application from any other contesting party or heir or quoted legal heir for the terminal benefits of the deceased employee. And in fact, as recorded in the order itself, the niece of the deceased employee had declined to receive uncle's assets and liabilities and voluntarily gave it in writing that she would stake no claim and relinquish the property in favor of the writ petitioner. Stop. The documents, including the above noted fact, before the sentence, order, what is recognized, albeit in a succession proceeding. Yes. Now, after that, and coupled with the, and then, but there's no other application by any other or legal heirs or heirs for different benefits. Miss, this is the problem. Problem. A decline writing.
Decline.
A decline, yes. Yes.
Decline to receive her uncle assets and liabilities.
And that should stick. I think that should stick no claim. Also relinquish the property in favor of the petitioner. Stop. Stop. The above noted facts clearly show that there is no doubt as to there's no doubt as to the fact that the petitioner was the above noted facts would clearly show that the relationship between the deceased employee and the petitioner was that of father and daughter, adopted or otherwise. Stop. It is to be it is also pertinent to note that in such societies, formal adoption papers are not drawn up, and adoption is usually done in a customary manner. So, taking this aspect, taking this aspect into account also, this court, in the consideration of this court, taking this aspect into account and the other facts as discussed above, in the considered view of this court, notwithstanding the non-availability of a deed of adoption, or a formal deed of adoption, the right of the petitioner has been clearly established. Accordingly, it is directed that accordingly the respondents number 7 and 8 are directed to process the release of the family pension of the deceased of the petitioner. The release and grant of family pension to the petitioner. Because also to recall that also take into account the fact that the state respondents or the employers have no objections to the release of the same. Next paragraph. The matter only stands allowed disposed of, but however it made clear that the judgment has been passed clearly on the peculiar facts and circumstances of the case itself, and shall not serve as a precedent in other cases.
Only if the time frame can be given, my lord.
Yes. It is further expected that the entire process will complete in a period of 4 months from the date of this order is. Correct it.
My lord.